Set for jury trial.
All right. Jury final settlement conference, June 6, 2025, 9 a.m. Jury selection, if necessary, June 9th, 2025 at 8:30. Both of those proceedings are in person.
Your Honor.
I'm sorry. I'd like to speak.
Okay, hold on. Yeah, counsel first.
I have jury selection Lawrence Buckner in the Ypsilanti District Court on June 9th.
The court session begins normally. The judge asks the defendant's name, and Carl Tinsley responds. The judge then starts organizing the case and prepares to move forward with scheduling.
Jury selection?
Yes, Your Honor.
Before Judge Barr?
Yes, Your Honor.
It'll be here.
Okay.
We all select on the same day.
All right.
So,
Your Honor, if I may. So Mr. Johnson and I are at a fundamental difference in defense strategy. There's no point in us moving forward together on this case. Mr. Johnson is representing me in circuit court. I've submitted a motion to have Mr. Johnson remove his counsel in that case.
Why?
Excuse me?
Why?
Why? Because Mr. Johnson is totally uninterested in this case, in that case, in this case as well.
Mr. Tinsley, you've been before me before, and I'm just going to tell you this.
Okay.
I haven't known Mr. Johnson necessarily all that long.
Okay.
But I'm going to tell you for maybe about the past year plus that he's been appearing before this court, there has not been a client that he has walked into this court.
The defense requests a jury trial, and the judge sets important dates. A final settlement conference is scheduled for June 6, 2025, and jury selection is set for June 9, 2025. There's also a brief scheduling conflict mentioned, but gets resolved quickly.
Where he has not been interested in their case and zealously representing his defendant. So I don't believe you. You coming before telling me that about this attorney? I don't believe it for 1 minute. Not 1 minute. I think, because you've been before, is that you're probably not listening to him. He is advising you. I can guarantee he's protecting every right you have.
And you'd be absolutely wrong.
Fullest.
I have not seen, this gentleman has told me he's going to show up to see me countless times at the county jail. He has not. I've been waiting over 2 years for discovery in another case at all. This gentleman doesn't answer his phone. You're making these assertions without having personal experience.
I'm done.
He
done.
If you want to file a tool for defense.
If you want to file, Mr. Tinsley, you're done. You're done. You are done.
The situation becomes tense. The defendant, Tinsley, says he and his lawyer have a serious disagreement and wants the lawyer removed. He claims the lawyer is not interested in this case and hasn't communicated properly. However, the judge strongly disagrees, defends the lawyer's professionalism, and suggests that the defendant may not be cooperating or listening.
Yeah, I think I need to respond to the 2-year comment. Mr. Tinsley does have a matter that's been pending for 2 years. I'm the 4th attorney on that matter.
I know.
I have only been representing him since April. When I go to speak to him, he doesn't want to talk about what I want to talk about, Giannis. I just want to clear that up for the record.
And Mr. Johnson, I meant my words sincerely. I've dealt with Mr. Tinsley before. This is a game he plays. So I'm done.
All right.
You're still on this case, regrettably, but you're still on it. All right. Take care, sir.
The lawyer responds, explaining that he has only represented Tinsley since April and that the case has had multiple attorneys before him. He also says the defendant refuses to cooperate during discussions. The judge sides with the lawyer, calls out the defendant's behavior as a pattern, and decides the lawyer will remain on the case. The court then moves on to the next case.